Hello and welcome to the next edition of our series of discussions about the issues faced by global law firms with UK operations, and particularly where there's a UK and US jurisdictional mismatch sometimes that the in-house counsel, the risk people have to overcome or have to try and find a way of reconciling. And I'm here with our excellent partner, Nick Leale. Nick is a leading regulatory lawyer in the UK and also has some amazing frontline experience of having to deal with these UK-US issues. So, Nick, today we're going to talk specifically about challenges around onboarding clients. And I wonder if you can just talk to us maybe about some of the key challenges that you've seen in practice.
Yeah, well, the two schemes in the UK and US are for onboarding clients are completely different. The issue often arises when a US partner wants to refer across a client to a UK partner of all of the issues that the UK then has to do in order to onboard that client. The identification that's required, the investigation in relation to corporate structures, if that's relevant, and just generally getting absolute clarity in relation to who the client is and who's giving the instructions. Issues that are always at the forefront of the mind for a UK lawyer when onboarding a new client, but in the US, particularly in a long-established relationship, may not be as established.
So within the US framework, regulatory framework, did these sort of know your client obligations not exist to the same extent? I guess know your client, know the source of their funds. Do they not exist to the same extent?
No, they don't. The investigation and requirements in relation to corporate structures and who instructions are being given by, and issues such as source of funds and source of wealth are just not at the same level.
Right. So if you're a partner, a UK-based partner, say in a newly merged firm, and you're trying to onboard a new client, how are you approaching your US partners to articulate the obligations that you have here when you're trying to onboard them?
Well, I think that's actually very difficult if there isn't if there hasn't been some sort of internal training in relation to US partners or a detailed policy in place in relation to what is required in the UK in relation to those sort of issues, because trying to explain them to a busy US partner with an established client who requires help in the UK is not necessarily straightforward when you're doing it from a standing start.
So if you were stepping back then and you had a bit of time to sort of train on both sides, how would you explain to the US partners, I guess, what the system is here and I guess the reasons for that system in terms of onboarding requirements?
It's interesting because I think when it comes to issues such as conflict, which we've discussed in an earlier discussion, it's more about educating the UK lawyers in relation to the US system, which has some additional complexities to it. Mm-hmm. Here it's the other way around because it's the UK that has the more complex issues that arise due to the risks of economic crime and the expectations on UK firms in relation to the anti-money laundering regulations and things such as that. But it's not easy to explain it all in a short period of time, and that's why it's important that I think the firms have in place a suite of documents and historical training that make sure that US partners really understand the systems.
I mean, do you ever see situations where US partners are almost discouraged from actively collaborating across borders, especially if it means that they're being asked to go to their existing long-established client and say, "Oh, can you provide me with a copy of your passport?" Which I've certainly seen as just a complete anathema to them.
I think it's a real risk, and a firm that I was at, where I was the European General Counsel, I saw that happening in practice because there was a clear indication from the UK partner that they couldn't assist the US client unless they had information that the US partners simply didn't possess and didn't want to go to and obtain from a client that they might have known for 30 years. The issue can be mitigated, I think, with some sort of documentation that US partners are able to put in front of those clients that isn't too weighty or too complex, that explains what the requirements are in the UK and why they are being asked to provide those issues. Because of course that client needs that help in the UK, and they're going to face the same issues, whatever firm they approach in the UK.
But having that a standardized approach, a policy, and educating the partners on both sides of the Atlantic as to this issue, and having sort of standardized documents which make it as easy as possible to explain.
Yes, I think,
and avoid clients feeling kind of affronted by this kind of request.
Yes, I think that's absolutely crucial, and that's what enables these matters to move forward, hopefully relatively seamlessly. And of course, these inquiries and all of this due diligence is in place for a reason in the UK, in order to protect the UK firm and the UK client. And one would hope that as long as people understand why it's being done, the client, when they're asked to do it, will understand that there is hopefully a benefit both to them and also to the law firm that's assisting them with the issues that they want addressed.
And just to be very clear, so anyone look, obviously from a UK perspective, we're all familiar with this type of know your client, know your source of funds type information that we have to get. But if for anyone listening from the US who maybe is less familiar, what are the sort of requests for information about their clients and support documentation that a UK partner might seek from them?
Well, identification through proper means such as passports, and further identification in relation to addresses, identification of directors, the structure, the corporate structure that may sit behind a particular entity that is seeking advice, clarity as to why the person providing instructions can provide those instructions on behalf of the corporate entity, and if you're dealing with a purchase, it be of a business or of a property, where the money's coming from for that, and what the source is of that money. Those are the sort of issues that have to be dealt with as run of the mill, really, in the UK.
Yeah, I mean, even just for us as a specialist firm, it's just part of every single client onboarding. It may not always be welcome, but I mean, it's just daily life here now.
Yes, and input from the partner overseeing the client file as to the possible risks both to the business and to the client in the firm acting. And it's important always that those sort of issues are considered and noted on a risk assessment. Something that is not as common in the US as it is in the UK either.
So that's an interesting question. So obviously here we are required to undertake risk assessments and have detailed policies. I mean, for UK firms, how do you see that do you see them rolling out into the US firms, or is it sort of localized within the UK operation? What do you see?
Yeah, I've certainly seen examples of where US firms with UK offices have begun to embrace those schemes themselves in any event, even where there isn't a particular obligation on them to do so. And I think we'll see the landscape change in relation to this issue in the coming years anyway. So perhaps it is an advantage to a US firm having a UK arm and beginning to meet the requirements of those sorts of regulatory schemes in any event.
Well, look, thanks so much. Are there any final words of wisdom that you have for us, or sort of practical tips?
I wouldn't call them words of wisdom, but I think it's pretty vital that any US firm referring clients to its UK office has a very in-depth set of policies and procedures and guidance in relation to these issues, so that when they arise, they can be resolved quickly for the benefit of the client in question.
Right. Thanks so much. And thank you. If you've stayed to the end, thank you so much. I hope you found this helpful. Please feel free to share it with colleagues if you think they would find it useful. And if you have any questions on this or other issues relating to regulatory partnership or employment issues around international firms, particularly with US and UK operations, we have a vast amount of knowledge and experience in this area, and we'd love to hear from you. And I know that Nick would love to hear from you as well. He sort of, this is his sort of lived experience, both as an advisor in private practice and also in house. So I know he'd be keen to hear from you. So look, thanks so much. Thanks again, Nick, and hopefully see you again soon. Cheers. Bye.